A temporary layoff can be an enticing option for an employer experiencing a short-term downturn in business. But a temporary layoff can be treated as a termination of employment with severance pay. This week on the Employment Law Minute, we're looking at the options for employers and the rights of employees surrounding temporary layoffs. Welcome to the Employment Law Minute, where we talk about common workplace issues and explore practical solutions for both employers and employees. I'm your host, John Scholes, and I'm joined by Ottawa employment lawyer Alex Lucifero, partner at Samfiru Tumarkin LLP. Alex, going to give you two questions. For the first question, here it is.
Sure.
What is a temporary layoff, and how is it different from a regular termination of employment?
Well, we know what a regular termination is, right, John? I mean, your employment definitively comes to an end when your employment is terminated. You're owed severance as an employee. As an employer, you have an obligation to pay severance or to provide notice or a combination of both. A temporary layoff is not quite a termination. As a temporary layoff, as an employee, you're effectively sat on the bench. You're sent home. You're told that your employment is not permanently ended. It's just on hold.
You're on ice.
You're on ice. We're not going to pay you. You're going to get to sit at home. You might be able to collect some employment insurance in the meantime. When we need you, we'll call you back. That's what a temporary layoff is. And there are certain rules and regulations around how a temporary layoff can be performed, how it could be implemented. And oftentimes, John, we see employers and we see employees get these kinds of things wrong. Most of the time, a temporary layoff is what we call a constructive dismissal, meaning an employer is not allowed to temporarily lay off an employee. We'll get into it right now in a second.
So they're not allowed to do it at all, or?
In most cases, the majority of times, John, an employer is not allowed to temporarily lay off an employee. That is the starting point. That's where the law starts, unless it's a term of your employment already. And that's the big catch. Now, there could be two ways an employer can implement temporary layoffs as a term of your employment. Number one is they can introduce it into an employment contract. So they can put very clearly in black and white in your offer letter, in your employment contract, that we are allowed to temporarily lay you off. If they do that, it's a part of a term of your employment. You accepted it when you signed off on that offer, and that's how it's going to go from here on in. The second way an employer can get away with a temporary layoff is if you've accepted one in the past already as an employee, meaning if you were temporarily laid off last year and you accepted that were laid off for a certain period of time and then were called back to work.
Set a precedent.
Well, you've set a precedent. Yep. You've now allowed the employer to do it once. They're going to be able to do it time and time again, every year, whenever they want, really. That's the two ways an employer can implement.
Let's rewind it to number one then. What can an employee do if they are laid off temporarily?
So, as I mentioned, a temporary layoff where there hasn't been any previous history of layoffs and where it's not part of your written employment contract is going to be considered what we call a constructive dismissal, meaning the employee is going to be allowed to consider their employment at an end permanently. So this is not temporary, this is a permanent layoff because it's the first time that the company is doing this and they're trying to force this on you. In a case like that, the employee is owed severance. Severance is going to be based on age, position, and years of service. The longer you're with that company, the older you are, the more senior position you were in, the more severance you're going to get. It's going to be way more, John, than whatever the Ministry of Labor tells you it's going to be. And that's likely the option you want to choose when you're faced with a temporary layoff. Because again, if you stick with the layoff, if you allow the company to do it and accept that layoff, it's going to become a term of your employment moving forward. You don't want to be in a situation where the company is allowed to temporarily lay you off like that.
Now, if I'm an employer, and I want that mechanism, how do I do it?
As I've mentioned already, you put it into your employment contracts. First and foremost,
from the start.
You don't necessarily want to rely on precedent as the basis for do that because, again, an employee might say no the first time that you offer that up to them. So as an employer, if you think temporary layoffs are going to be a tool in your arsenal that you want to use, you want to make sure that it's included in your contracts of employment. Contracts of employment have to be very, very carefully worded, John. They have to be very carefully implemented. You can't just introduce a contract midstream employment without some specific requirements. So you got to do that properly. And I would encourage employers who want to introduce temporary layoff provisions to contact us to do so. You bet. Alex, good stuff there. We're going to leave it there for now. Are you experiencing issues in the workplace? Contact us now. Help at employmentlawminute.ca. The phone number is 1-855-821-5900. Go to employmentlawminute.ca. You'll find past episodes of the show, resources for employers and employees, as well as contact information to help you find practical solutions to workplace problems. employmentlawminute.ca. Thank you for watching. We'll see you next time.